and that is the contract with Tyler Technologies, who is our town assessor. And we've all got a copy of that in front of us. The new contract for this year is about, it's virtually word for word, or is it word for word?
There is a section for, there's a section added in the back page for the internet use and the cost for running that, where they'll semi-annually charge the town at a rate in the back of the sheet. So the 26 grand would be in addition to it. Typically, it runs about $950 for them to do, but typically the town is budgeted $27,500. It's up to you guys what you'd like to do.
Jenny, what page are you speaking of?
Can I see that for a second? And I apologize, I should bring it open. Page 13, K is actually in the old contract, and under the 2.0 at the bottom of 13, however, they added just a little bit more verbiage to go to the Schedule B in L. And to include in with the contract, to include the cost of running that online that we have on our website.
You're not aware of any requirements at this time to reassess the town at full? We just did that.
We just did that, and that was that capital
There's no-
budget last year. Or that was 2012, I'm not even sure.
Mr. Chairman,
Yes.
maybe just even to, I'm not sure I got Mr. Paget's question exactly correct, but the contract we're looking at, the terms of payment is for the fixed fee of $26,000, so it is not a function of how much property value they can assess or that type of thing. It's for a fixed fee for the 2014 calendar year.
All right.
Jamie, page 15, this time on material rates, is that Schedule B? Did they reference a Schedule B, they reference a Schedule A? In my packet, I didn't see either online, nor do I see it here in the hard. The one right down the top.
It's
Yeah,
squished.
Gotcha. Okay, thanks.
Okay, sure.
Hector, have you had a chance to look the contract over?
I was not asked to look at the contract, but I did look at it to not leave the town in a lurch. And I have a number of comments, if you care to hear them.
I think that's wise.
The contract is for the assessment year of, the entire assessment year of 2014, and the assessment date is January 1. The contract does provide for the compensation to the assessor, that compensation should be increased to the assessor should there be occurrences which materially increase the difficulty of the project, and that would be your very last line of the top paragraph on page 2. So while you do have a fixed price of $26,000 for the contract. If you look at the merger provision in the contract, the merger provision being basically that if it's not in here, it's not part of the contract, you will note that the contract is silent on the performance of duties in the event that there is an appeal to the Department of Revenue following the Board of Appeals. It is also silent on what the cost will be in the rare event of an appeal to the circuit court. This more often than not occurs with regards to commercial properties, but it is something that I am seeing in other settings. In addition, the contract on page 4 has indemnification language which obligates the town to indemnify the contractor. And in reality, the only obligation of the town, aside from making space available, its records available, and personnel to assist in responding to inquiries, is to pay. So my recommendation would be that there be a deletion of indemnification language here, because it might be a burden on the town and certainly something that should be run past the town's insurance carrier.
Hector, is that the same language that was in last year's contract and probably the contracts for any number of years since they've been out?
Quite frankly, I did not look at last year's contract. I was not asked to look at last year's contract. And I was not asked to even look at this one. So
No,
I
last
can't
year.
answer your question.
No, last year when you looked at the contract, would these
I
comments be the
was
same?
not
since-
asked to look at the contract last year, sir.
I see.
Okay, and that's why, I'm pointing these things out to you. In addition, with regards to the insurance obligation, the assessor does have to carry insurance, but I would recommend that there be a negotiation for the inclusion of the town as an additional insured. That is, the town, its officers, its employees and agents. And this contract is with an entity that really is incorporated in the state of Delaware, as you will see on page 1. And there's a provision that allows them, in paragraph 15 on page 6, to basically assign the agreement to somebody else. And I would recommend that the town attempt to have language included that the town should have full discretion to grant or withhold approval of the assignment of this particular contract in the event that there's a buyout, because the town certainly is entitled to know who's taking over and to raise reasonable objections if it's a new startup firm with no track record or limited staffing. In saying these things, bear in mind, based on my experience in working with the assessor here and the company that has offered this contract, I have seen no problems, and I have felt that they have done their work in a very professional fashion, so please don't infer that I'm suggesting that there have been problems. Finally, the contract itself, the length of the contract, even though it covers the entire year, if you look on page 7, paragraph 21, it basically says that the contract may be terminated by either party by giving 30 days written notice to the other. And there is no cause provision. So if for some reason there is a disagreement that might occur, the town can find itself with a notice of termination for 30 days, and the town will have to find someone else to take over. And there is language in that section also about the town being obligated to pay for services rendered to that point. And if the termination results from inefficient performance, and I have seen this happen in another community, it doesn't often happen. It's a very frustrating proposition because in many cases, the contractor has records, the records may not be complete, there may be issues which should be resolved, but paragraph 22 of the agreement calls for the mandatory arbitration of any dispute. And in many ways, that ties the hands, in my opinion, of the town in basically being able to say to the contractor, look, if we can't work this out, we will have to work it out in court. And arbitration is a very closed and sometimes arbitrary way of resolving disputes. Those are my comments.
Mr. Chairman?
Yes.
A couple of things, and thank you, Attorney De La Mora, for giving us your thoughts on that. I guess I have a general suggestion, and then I have a very specific question for you, but the general suggestion would be, I think we need to ask Attorney De La Mora to put, basically take and red line a copy of this with your suggested changes. How long would that take you to do that, would you estimate?
As quickly as my copy can be photocopied. I have blue lined it. And I have it here.
I don't too much care about the color, but you've got it marked up with your
It's right here, and
suggestions.
it's available.
All right, so that would be your suggestions as to what we ought to respond back to Tyler Technologies with, is that what I'm saying?
Well, at least explore it with them to see what can be worked out.
Okay. Then I've got we can come back to that. I think that's the direction we ought to head. But I've got a specific question, and I think if I understood you on paragraph 15 on page 6, you were concerned about the paragraph entitled Assignment of Agreement. And maybe I don't understand you, but the wording on that says the company agrees not to assign, transfer, convey, sublet, or otherwise dispose of the agreement or its rights, titles, or interest in this agreement without the previous consent and written approval of the town. Maybe I misunderstood you. I guess I thought you were concerned that they could do so. It says they cannot.
Well, again, in an effort to abbreviate my comments, what I had commented on here, as you'll see when you get my copy, is that we should put in language that the town shall have the full discretion to grant or withhold approval of the assignment. Because oftentimes when I've seen language like that, the comeback is, well, we're giving you the opportunity, you're being unreasonable in denying assignment.
I guess I don't have a problem if you think the language can be changed, but I thought you told us this was assignable, and it says they agree not to assign, transfer, convey, or sublet.
Without consent.
Correct, of the
Yeah.
town. Without previous consent and written approval from the town.
Yeah.
So that's pretty clear to me that it's not assignable.
What would you change the verbiage to?
I would add verbiage to that paragraph, that the town shall have full discretion to grant or withhold approval. That's the only thing.
Already says that.
No, it doesn't say that we have full discretion.
Without the previous consent and written approval of the town.
Well, those are my comments.
From my perspective, paragraph 22, I'm absolutely fine with arbitration rather than going into a court of law. Cheaper for all parties. How long has Tyler Technologies been our assessor about? My understanding is it's been over 15 years.
I'm sure.
Are you aware of any previous problems with them? Any issues? Other than, of course, over-assessing some of our homes?
Just one more, I guess, shut back, and again, take the opportunity a little more. Would you have your blue line copy, does that have specific language in it? I mean, is this a markup with specific language you're recommending, or is it just encircle and say these are areas of concern, or what is it?
It has specific language. That's what I said a moment ago.
Okay, well, I guess I'm thinking that it would be well for the, I mean, I appreciate you verbalizing that, but I guess I would think it would be wise for the members of the board to see a copy of that, to see the specific language you're proposing.
Sure. That's my thought. Jamie, is the number of $26,000 in the budget that we had last year, was that inclusive of their other, the little, you know, the appraisers call up because they don't want to look at the square footage and we have a separate bill that we pay?
No, the only separate item that was done back in 2012 was the reevaluation. And that was done as a capital outlay. Otherwise, this flat amount is for everything, board of review, all of the items, them coming in for appointments, them sending out the notices, everything.
Well, I'd make a motion to approve, award the contract to them. My motion would have a caveat that Hector have the opportunity to review the contract and make sure that language that he recommends within the contract is in place to protect the town as our attorney. And that is my motion. And will, Hector, you can do that language in like less than an hour, right? Since it's all done. Authorize, I'll add to that motion that Hector's authorized for up to 1 hour to work out that language to get that in place.
I'll second that motion.
A quick question then, Joe. All of the language that Hector wants in there, what if Tyler doesn't, what if they find some of it objectionable? I guess if they,
I doubt they, my read is that I don't see that they will find the subtleness or positioning objectionable. There's no reason for that. There's never been any animus other than our tax assessments being maybe too high. So I can't see that. And if there is such a problem, then I think that Hector should work the clerk and it should get placed back on an agenda for the next meeting and come back and visit.
fair enough.
I guess just a comment, I can embrace the spirit of where you're headed, Supervisor Vansky. I guess I would like to have this put on the agenda for the next meeting so it can come back and we can see what, and I'd actually like to see a red line document, what we have put back to them and see whether they've approved that or not. I'd just like to have the opportunity to see that, so if that's a reasonable expectation, I'll support the motion.
Would you like to have, would anybody like to have the, Mark Link, the state supervisor for Tyler Technologies here at the next meeting then? Okay, so we have any questions for him?
I think the motion currently is to approve the contract, let Hector work that out. If he can't work it out, he's to come back to the clerk and say, I can't work it out within the hour that I was given. I can't work out the language. To protect the town, we're not talking about the dollars and the cents. We're talking about the breadth of the language underneath the non-assignment. These seem to be minor tweaks, a minor tweak to list us as an additional loss insured on an insurance policy. That should be at no cost to them. I can't imagine that would be a sticking point, and I didn't hear a lot of other changes. I don't see that there's a reason to delay it, or bring it back. I guess, Mr. Fisher, if you wanted to volunteer your time to work with Hector.
No, I'm not volunteering my time, I'm not volunteering my time to work with him, he's got it under control. My only request, I guess, of you, Joe, would you accept a friendly amendment that this simply be put back on the next agenda so we can see the progress of that? Would you object to that?
I don't think it's necessary. I'll do it as a courtesy to your request.
I appreciate that.
I don't see that, if from my seat, I don't think it's necessary. So I would accept that change, that it would come back, so then we would table this to a date certain. Would that be the right?
No.
How do we approve a contract and then bring it back for revisitation without tabling?
I simply want to see what the changes are.
I don't know how to address your concern then and not table it to a date certain.
I would suggest you're accurate, and we should probably table it if you want it, if Supervisor Fisher wants to bring it back and just look at the language before we agree to award the contract, then I think it would be proper to table it and bring it back at the next board meeting.
I believe I have to, Hector, you can chime in, do I have to withdraw my motion, or can I amend my motion to a table to a date certain? What's the right hoop to jump through?
I think the nature of the amendment is to substitute for your motion, which is for approval, the mandate that the changes be brought back to the board for its consideration. That's the nature of the amendment. Am I stating your position, Mr. Fisher, correctly?
Yes.
Thank you.
Got that, Jamie?
What was your last sentence, that was number two,
That the nature of Mr. Fisher's motion is, or amending it, is to substitute the directive that this matter be tabled rather than approved.
So Mike, you seconded my motion, I think you have to second my
I will second.
change to a table to a date certain to allow the contract to be brought
Correct.
back.
Read it back, please.
Sure. Supervisor Bansky moved to approve the 2014 Tyler Technologies Assessor contract with Attorney De La Mora for Attorney De La Mora to review the contract and to provide Tyler Technologies up to 1 hour with the language to be provided with discussions included with Tyler Tech, with this item placed back on the October 10, 2013 agenda with final changes. With the substitute to the directive of this matter to be tabled to the October 10, 2013 meeting.
Thank you. Any further discussion? All in favor? Opposed? Motion carries.